and then they will also have a rebuttal after the appellees make their argument. So I will now call 124-130 Hodes versus Nauser versus Hody and Nauser versus Kobach. I am sorry. Would council please come to the podium and state your appearances?
Good morning. May it please the court. Anthony Powell, Solicitor General on behalf of the state of Kansas. With me at council table is Dwight Carswell, the Deputy Solicitor General. And the state would like to ask 5 minutes for rebuttal. Reserve, please.
5 minutes is granted. Thank you.
Good morning, Madam Chief Justice. Alice Wong with the Center for Reproductive Rights for Plaintiffs, Appellees, Doctors Hodes and Nauser. And with me at council table is Teresa Woody, present and ready for argument.
Mr. Powell, you may begin your argument.
Thank you, Chief Justice. May it please the court. Anthony Powell, the Solicitor General, appearing on behalf of the state. Before I get into the substance of my argument, for the benefit of the court, but mostly for those watching, just to briefly remind everyone how we got here. This case concerns whether KSA 65-6741 et sec, which prohibits dismemberment abortions, violates a woman's right to an abortion under the Kansas Constitution. A dismemberment abortion is broadly defined as the killing by dismemberment of an unborn child and then extracting the pieces from the uterus. It is just one type of dilation and extraction abortion. Testimony before the legislature described the barbarity of the procedure. Just before the law went into effect, the plaintiff sued, claiming the statute violated the Kansas Constitution. The district court temporarily enjoined enforcement of the statute, and an equally divided Kansas Court of Appeals affirmed. This court granted review, and for the first time ever, this court held that Section 1 of the Kansas Constitution Bill of Rights protects a fundamental right to personal autonomy that encompasses the right to an abortion. On remand, the district court granted the plaintiff's motion for summary judgment, holding that the statute violated a woman's right to an abortion under the Kansas Constitution and permanently enjoined enforcement of the statute. We are before you this morning on the state's appeal of that ruling.
Mr. Powell, what you're here on initially is you're asking us to reverse our decision that we previously made in this case.
Correct.
And you had 21 days to file a motion for rehearing or reconsideration of that decision. That wasn't done, or you're kind of here in a posture saying there's an unlimited time to seek rehearing or modification. And do you have a response to that? Because I typically in cases like this, your office files all the time motions for modification and rehearing. They're sometimes accepted, sometimes not, but you didn't do that here. Why should we take this up?
Well, you have him at a bit of a disadvantage, as you know. General Kobach and myself only took office in January, so we weren't running the show at the time that the first Hodes opinion came down. But I think because the question here involves such a big one, we're talking about an interpretation of our state constitution, really a case of first impression, involves a very important issue of abortion rights. I don't think that there should be, in essence, a statute of limitations on when we should ask reverse. And it's not
asking how we should factor that rule in this case when it wasn't followed. Basically, you're seeking almost an indefinite time to file a reconsideration. You're also asking us to you're asking us essentially to find that our original decision was clearly erroneous, manifest injustice. And I want you to focus on law of the case. Why doesn't the law of the case doctrine that you're familiar with and that we follow traditionally in cases once a ruling is made, that's the law of the case for the entire case. It doesn't get reconsidered, set aside unless there's some sort of manifest injustice or we were clearly wrong. And the points that you make that were clearly wrong, I looked at the original briefs in this case, filed way back in 2017, 2018. It's the same points that were made then. We addressed them in the original case, and now you're bringing them back up again. So how are we clearly wrong, given the status of what's before us now?
Couple of things, Justice Rosen. First, you're not the only court in this country that has been asked to do this. And I think you can look to the Iowa Supreme Court, which changed its mind. And
Different state and a different constitution.
It's true, but I think it's what we're talking about, though, is the constitutional right to abortion. And we also have to consider the fact that the United States Supreme Court issued the Dobbs opinion. And even though that's under the federal constitution and we're dealing with the state constitution, I think, to be fair, certainly in my mind, if I were still hearing and sitting on a case such as this, you can't deny the impact of that decision. It's changed the landscape considerably. And we think because of that decision.
How's it changed the landscape for us in Kansas? We're
Because
dealing with the Kansas Constitution.
Because the U.S. Supreme Court has said that it's an issue, the issue of abortion should be returned to the people and their elected representatives, and that there's no historical or traditional right to abortion. And I think that's significant. And I think the court should revisit that, revisit the issue because of that.
Well, if we're going to revisit it, Dobbs, said we should return this issue to the state and to the people to persuade one another, and then vote. And we've done that in Kansas. We had a vote in August, and it's pretty overwhelming to reject the proposition of amending the Constitution. And so, I think that's the elephant in the room, or one of them. And how do we factor that in when you're asking us to change our view, our interpretation, which is our job, of the Kansas Constitution when the people spoke so forcefully?
Certainly a fair point, Justice Biles, and I've got a couple of responses to that, if I
think
might.
a few other of my questions are fair too.
That's fine. First, I think as a matter of constitutional interpretation, because the Constitution wasn't amended, I don't think it changes the analysis. I still think we have the Constitution as it was, both before the vote and after the vote. And so I think our arguments are still matter. But on the issue of is the public by its vote, did it signal an endorsement of what the court did in Hodes? And I guess my response to that is I'm not sure we can really say. I know that the media and some people like to think that it is, but before I was a judge, I was involved in politics, and sometimes the voters surprise you and you don't always know for sure what they're saying by the way they vote.
But doesn't the ballot question tell us that? I'm looking at the ballot right now.
Well,
And
sure.
it says a vote against the value of them both amendment would make no change to the Constitution and could restrict the people through their elected representative from regulating abortion by leaving in place the recently recognized right to abortion. That's a pretty plain disclosure to the people as to what's going on here. And a whole bunch of people voted. More people voted in that primary than have voted in years, decades.
It's true. And that argument would impress me more if the campaign was centered around that, what the proposition really entailed. But
I look at that and not the ballot.
Because that's what
the campaign's not in the record. I can take judicial notice of what was on the ballot because I can look at it. So I think we got to be careful about trying to bootleg too much.
Well,
into this
but
record.
the question, I guess you're asking me the question of,
Sure.
didn't the public endorse what we did, counsel? And I'm trying to give you an answer to say, I'm not convinced that that's the case, because I listened carefully to the debate over that amendment. And I listened in particular to what the opponents of the value them both amendment had to say. And they said two basic things. One, they said that the amendment, if passed, would ban all abortions. And so I think you can probably take then from the public's vote is that they were saying, we don't want to ban all abortions. Fair enough.
Counsel,
The
even,
sec-
oh, I'm sorry, you go ahead with your second point.
the second point is that they made was our state law has reasonable restrictions on abortion. And that's really all we're coming to you today to ask you to uphold is a one reasonable restriction on abortion. It's our view that that's consistent with what the public was trying to tell us with that vote. And our concern is that with the strict scrutiny standard that the court has said must be applied, we're concerned obviously that reasonable restrictions on abortion like dismemberment abortion, which is in our view and in the evidence that was presented and testimony in the legislature, it's a particularly heinous procedure. It involves the dismemberment of a live unborn child.
What
the
evidence was
pieces.
produced at the district court on remand about any heinous procedure or?
Well,
I mean, I know that that you cited to legislative testimony, which is untested, obviously. But what was there anything in the evidentiary record about
the
heinousness?
description, it's the description of the procedure itself that makes it heinous. So yes, I am giving a pejorative description of it, but I'd like to think that we can agree that the dismemberment of a live unborn child is a particularly gruesome
The
thing.
problem,
That's
Mr.
what we're
Powell, is
talking
the
about.
alternatives that you offer, and I'm sorry, Justice Stiegel, I think you're gonna make a.
I will ask a question in a
I'm
moment.
sure, I don't doubt that. So anyway, I lost my train of thought. The problem is, at least not the problem, but you've presented alternatives to Senate, the D&E procedure. And the testimony that is before us, that's untested procedures, much of it. And it's equally, if you look at the description of it, because that's all you're providing us is a description. I don't see a distinction at all. And in fact, it puts the mother at a much greater health risk than the procedure that you're complaining about.
Well, I'm glad you brought that point up. First of all, I do think respectfully that there's a difference between pulling the parts off a live unborn child versus causing fetal demise through the injection of some drug.
What's the
I think that's
evidence of
different.
that? That's my problem here. There's no evidence that what's it called? Let's just take anamorphic injection of digoxin, however it's pronounced. There's no evidence that that's a more humane way to die. It has a 20% failure rate. It sometimes takes a second dose for which there's no medical research on. So how can you say one's more humane than the other? There's no evidence of that in the record,
Well,
right?
true. It is, that's true. But there are, and this court, I think, can take judicial notice of the records in other cases. And we've cited in our brief, the Whole Woman's Health case, v. Paxton from the Fifth Circuit, where there was much more extensive record in that case with regard to this procedure. And here's what they found.
Are
in
you,
that case.
I don't want to interrupt, but are you suggesting that we accept as for the truth of the matter asserted as evidence, something that was produced in another lawsuit in another state after a 5-day trial?
Justice Biles, what I'm suggesting here is that the evidence that was presented by the plaintiffs, if you look carefully at what they said, I have to say, just having been a district judge, having been an appellate judge, I found the statements that they make that are purporting to be facts to be broad, almost conclusionary statements at some level. And you're being asked then to review and make a decision upon the propriety of particular abortion procedure. And I think to consider additional facts that you can take judicial notice of would be consistent with your responsibility for trying to decide this question. It's a big enough issue.
Would you agree in
that I
this
think you
case
have to do
that the facts that were submitted by the plaintiffs that you're saying are conclusory were supported by evidence, affidavits by experts?
And like I say, I think
In
if you
this case?
if you look at what they said, though, in some cases, I found them to be conclusory.
Right, but they're supported by expert affidavits. Is that yes or no?
Yes,
Okay,
yeah, I don't disagree
case,
with that,
right.
but I'm
And
saying
more-
it's the
I mean, and
substance.
really, and more importantly, the
substance of-
district court found these as facts. I mean, and you've made no challenge, the state has made no challenge to the uncontroverted factual findings the district court made based on a lack of substantial competent evidence or anything like that. I mean, really, the state stuck with the facts as found by the district court, regardless of what you think about those facts, right?
I acknowledge that.
And isn't that after the district court gave you the opportunity to depose these experts to drill more into the detail that you're saying is lacking?
That's true, chief. But again, this is a big issue and I'm dealing with some limitations here. I basically was parachuted in, at the 11th hour. And so I understand the record is what it is. There are some, deficiencies, I suppose, at some level, but in terms of trying to decide the legal question here, I think it's important for the court to look at not only the record in this case, but the record that has been made in other cases that can be helpful to you in deciding this question. I don't think that's inappropriate. I think we do that all the time as appellate judges, and that's why I'm making that point.
I guess I'm lost on that, connecting the dots on that. Judicial notice, under what provision do we take judicial notice of facts in another?
Well, because another court made factual findings about this procedure that I think is relevant to your consideration of the case. And that's why I'm making reference to it. I think we do that when we're making decisions on cases. We're comparing facts, and they made a decision in the Fifth Circuit talking about, they upheld it. It was under a lesser standard of undue burden, but there was an extensive factual record made in that case. And there are factual contentions and findings in that case with regard to this procedure that contradict some of the evidence in this case. And I think it's important for the court to be aware of that. And I don't think I think the court should have its blinders off and try to, decide this case, having the greatest possible amount of resources in front of it to make that decision. That's really what I'm asking. But I understand the limitations that we're under.
If I could, I'd like to go back to the question of the impact, if any, of the August primary vote. And you were engaged in a bit of a back and forth with the court about that. And I think the sort of premise of that back and forth was, can we tell from the vote whether or not the people of Kansas were, quote unquote, endorsing this court's earlier decision in this case? What I want to ask is, assume with me that we can tell. Just assume that it's sort of beyond question that what the people of Kansas were doing in August was, quote, endorsing the opinion of this court. As a matter, I understand why that matters in terms of representative democracy, political considerations, but as a matter of constitutional law, why would that matter?
Doesn't matter.
And why not?
Because this court is charged with reading the words of the Constitution and interpreting it according to what the words say. And our position is that when you look at the liberty interests in Section 1, and then you expand that to personal autonomy, you're still trying to figure out, at least in my mind, when I think of, the whole reason we have the test the Supreme Court has laid out was that in order to find a liberty interest, you have to find that right has to be clearly identified and steeped in our
But
traditions. And
aside
history.
from even just this case, just as a question of how constitutional law works in our system of government where the judiciary interprets the law. I mean, one of the things we often say as a court is that we don't take public opinion polls about the meaning of the Constitution. From your perspective, is that what the plaintiffs are essentially asking this court to do with respect to the August primary vote?
I don't think that, the vote, as I indicated in my initial response to Justice Biles, is as a matter of law, constitutional interpretation, a public vote doesn't matter, particularly when the Constitution wasn't changed. It might matter if the language was changed.
Well,
and
it
then
certainly would matter because we would have new language,
Right,
correct?
exactly.
But you're asking us, I'm sorry, Chief. No, along the lines of constitutional interpretation. And we don't, and I understand the argument that the primary may mean something, may not mean something. You argue that the personhood amendment passed by the legislature frames the compelling interest in this case. And why is that any difference? Why does the legislature's enactment of a statute tell us what the compelling interest is over that of anything else? Why is that any difference? We said strict scrutiny in our original case is weighty, possibly urgent, but also rare, much rarer than legitimate interests and rare than important interests. And so your argument is the personhood amendment, and the district court found, based upon an argument with no evidence, that satisfies the compelling interest, that creates the compelling interest in this case. And then you argue something entirely narrower. But anyway, just react to that. Why does the legislature get to say what the compelling interest is
Because they're
in our constitutional analysis?
They're the representatives of the people, Justice Rosen, and so it's their
How's
values
that any
that they're,
different than voters saying what they're saying?
because they put it into the law. And they're saying, what would be a better way to say what personhood is than the legislature enacting the law saying what personhood is? That seems to be much more important or weighty than having unelected justices make that decision.
So the legislature, by exercising their police powers, which they typically do, and creating statutes, it raises the bar and can create a compelling state interest by legislation they pass.
Well, maybe not in every case, but certainly in something like this, when we're talking about fundamental values. And that's really, I think, the difficulty that we're struggling with over abortion. If this were just merely about personal autonomy, if there wasn't another individual at stake, which is an unborn child, we probably would be having these constant debates and litigation over the past 50 years. But the simple truth is that we have this clash of ideas. We have this clash of values that's not getting resolved through judicial fiat. And that's, I think, is a problem. And I think that's what the Supreme Court in Dobbs recognized, is that this issue can't be resolved by the judicial fiat. And quite frankly, having been a member of the judiciary for 20 years, I think it's undermined confidence in the judiciary. Respectfully, it has. I mean, there have been controversial decisions that have come down from this court, from the United States Supreme Court, and when they really rest on first principles, people, even if they initially disagree, they come alongside and accept it. Why has abortion never been accepted? Why is there's this constant turmoil and fight over it? And I think the court should ask itself that question. When I think of the legitimacy of the court, I think of Federalist 78, when it talks about the judiciary, you don't have the sword, you don't have the power of the purse. What you have is judgment.
Counsel, aren't courts essentially stuck with the legitimacy problem as you're describing it? In other words, I'm familiar with the argument. I don't quite see how courts can sidestep that. And I will put to you the example of the United States Supreme Court in Dobbs. And of course, as you know, the legitimacy argument was one of the primary arguments made against the United States Supreme Court. The suggestion, and I think public opinion polls probably back this up, is that court lost legitimacy when it overturned Roe versus Wade. And so it just strikes me that at some level, courts cannot sidestep that legitimacy problem. Do you have any thoughts about that?
Well, let me clarify, obviously we're not about chasing legitimacy from the public. That's almost like you're doing polls on what your decisions are. And that's not what I'm saying. but there are significant bellwether historical decisions that this court makes. And I think it matters whether they're ultimately accepted over the long period of time. And abortion, we've been fighting about it for 50 years. And even with Casey that purported to uphold it, it changed the whole rationale. And I think that the whole reasoning behind it's been criticized. And I will just say respectfully, it's my prediction that this court's decision in Hodes won't be accepted either. We're going to continue to see challenges. The people are going to want to express their values, and they're going to feel stymied by this court. And I'm just saying, being frank with this court and trying to be a truth teller from this podium the best I can. I know you're all serious people since I know all of you, but I think it's important to make that point. It can't be overlooked.
But aren't
you-
you several times, I'm sorry, if you're asking a follow-up.
Oh, go ahead. But aren't you just saying in a little different way that you're asking us to take a poll of what people want in arguing that?
I think what I'm really asking is to rise above it. It's public opinion shifts back and forth in the short term, but this is a long term. We're talking about the basic I'm asking the court to consider its place in our constitutional government, and that there are some issues, and I think abortion is one of those, that can't be resolved through judicial fiat, no matter how hard you try, because we've got this basic conflict between two different values. We're trying to weigh the value of the mother and the situations that they're facing with a pregnancy, and then we have the life of an unborn child. And the only way I see that we can have the hope of trying to wrestle that question to the ground is you've got to let the people work that out. Because in the issue of abortion, and Justice Scalia said it, I think, well in his dissent. He talked about when you return an issue to the people, the losers feel like they got their day in court. And I submit to you that for 50 years, pro-lifers didn't feel like they got their day in court. And now they feel like with the US Supreme Court decision, they have the opportunity to make their case to the people and to the legislature. And I think what we're asking for is we want you to give the people of the state and their elected representatives the opportunity to make their case. And I think that's the only way we have a hope of trying to wrestle this issue to the
Well,
ground.
I guess I do have a follow-up question on this
Okay.
before I go to my other different line of questions. That's true in every situation. The balance of powers, the check on us is through legislation and constitutional amendment. That's always there, regardless of what the case is. And so that was what was played out in August. That was the opportunity. And I don't know that there's a cap on that opportunity. I guess maybe that's more of a statement than a.
You're not
So-
wrong about that, Chief. I mean, certainly I would expect, it wouldn't surprise me that the people may come and there may be another effort to amend the Constitution at some point. But I think the US Supreme Court got it right when they said, this isn't an issue truly about the law. This is more about values and a clash of values and who gets to decide which values control. And I think if we let the people through their elected representatives do it, we're going to have a better result at the end that's going to take into account all the variety of interests that we're looking at. It can be much more nuanced instead of having justices of the court who aren't elected try to make those decisions.
That may be
That's our
true, but-
basic point.
That may be true, but aren't we constrained by the law? We must interpret the law, correct?
Well, what constraint though? I mean, here the court has taken the word liberty and then you've expanded it into a very large subset called personal autonomy. And then out of personal autonomy, you plucked abortion out of that.
Well,
And
then
so
let's back up.
People who look at that, Justice, say, this doesn't strike me as interpreting the Constitution. It looks like it's the values of a majority of the justices of the court saying this value we think is an important personal autonomy right. And so we're going to ensure that it's protected. That's how a lot of people look at it.
And let's
That's the
back up
concern.
to the wording of section 1 that talks about, it acknowledges that people have inalienable natural rights, including life, liberty, and the pursuit of happiness. Not specifically included in that is bodily autonomy. Set aside the abortion as a specific form of bodily autonomy. Whether you consider it a property right or a liberty right, wouldn't you agree that bodily autonomy is a person's inalienable natural right?
Of course, I don't disagree that this notion of bodily autonomy, personal control, the right to be left alone, that those are all important rights that we all value as Kansans and as Americans, but.
So
you're
you
taking
agree
it-
that's
the
where
court-
we must start under the law?
I'm sorry?
So you agree that's where we must start under the law?
I think that using that understanding and the history that the court has laid out about personal autonomy, I don't have a strong quarrel with that. But what you're doing is that's still not a clearly defined right that we can then seek to enforce in the court. You still have to take the next step. And what the court did is it took the next step and said, well, abortion is one of those rights, and we're going to give it that fundamental right protection, even though there's not a history in the state of protecting that.
But if
right.
the government wants to restrict or interfere with personal bodily autonomy, shouldn't that be read narrowly and defined clearly before it is allowed under the law?
Well, how I look at it, when you look at bodily autonomy, I'm thinking all the things that might be bodily autonomy that in fact we don't apply strict scrutiny to. I mean, when you think about the recent fights about vaccines, that's certainly an issue of bodily autonomy. I don't see the courts applying strict scrutiny analysis to efforts to protect the public through mandatory vaccination, for example. I think of the laws that regulate tobacco consumption or alcohol consumption, or how about all the laws we have prohibiting illegal drugs? I'm thinking in particular like fentanyl, or even the debates that we've got going on with marijuana. Those are all, I mean, you could make an argument, a good argument, that personal autonomy should include the right to consume whatever you want. So I guess I'm wondering, is this court then prepared to apply strict scrutiny to all those areas of personal autonomy that the government regulates now?
In along those lines, let me just drill down a little on what I heard you say. Is it the state of Kansas's position that Section 1 protects a quote right to personal autonomy or bodily autonomy, excuse me?
Well, our position is that Section 1 isn't enforceable in a general matter.
What does
but
that mean, that it's not enforceable?
It's in the state's view, it's not enforceable because it's this generalized
So it doesn't
right
have
that-
any meaning.
that it's hard to truly make it into a discernible right that can be enforced. That's our position, but I haven't focused on it because I'm aware of the fact that the court in Hodes was unanimous in its view that Section 1 did have enforceable rights. And so I'm really kind of stepping back and saying, well, how do we create it or identify an enforceable right from such broad terms like liberty or personal autonomy? Because in my mind, personal autonomy might be a subset of liberty, but
Can
it's
you,
still very broad. So you have to go something and say, well, what personal autonomy right are we really talking about? That's where it gets tricky.
so,
And that's where I think there has to be a historical basis for it.
and so let me follow up on that. If now we're getting to the nub of it. What does Section 1 really mean? And you acknowledge that the court unanimously in the earlier decision held that it was not a quote glittering generality, which is of course a historical phrase that represents the position that you take, that it essentially is meaningless. It's puffery, it's mere smoke, right? But the court, even in a divided opinion on the substance, the court was unanimous in holding that no, this is part of our Constitution. It can't be meaningless. So if you take that as the as the ground floor. Does the state have a position? Is the state claiming is the state staking out ground on what it actually means?
Our
Or
view-
are you just sort of,
Our view, in order to define what liberty means in section 1, have to, one, state specifically what the right is, and 2, it has to be supported by tradition and history of our state. And our
Exactly
view,
where I wanted to.
and our view is that abortion doesn't fall under that. That's our view.
That's where I've been trying to jump in for 25 minutes now. That test is the test that the US Supreme Court restated it, at least in Hobbes. I mean, so how does that fit with the history of the constitutional history of our state? As a backdrop, I know that some opinions of both the Court of Appeals decision in this case, as well as our decision in this case, go at some length into that constitutional history. And just for the listener to frame it, we are talking about the various constitutional fights over whether we would be a free state or not. And more specifically, when it got to the discussions about section 1, there were that was probably the most talked about, or perhaps section of the Bill of Rights. And a lot of it was because people were afraid that through that language, they would either lose some of what would be put into another provision about slavery, or, hey, maybe this is a loophole for those who felt on the other side of the question, that we should have the ability at least to help enforce other states who believed in slavery and be able to pursue runners, I guess would be the way we talked about it. And so the Constitutional Assembly looked very, very close at what that language should be and how they could most freely separate themselves from what was then deeply rooted in our nation's history and traditions, the concept of slavery. Our state was really founded as a rebellion against those values that were deeply rooted in our nation's history. So why should we, when we're looking at our state constitution, and more in particular, section 1, use that test as our litmus test for what we would protect?
Because I think to have an objective standard that we can all sort of trust in when we're trying to root out what liberty means or personal autonomy means, it's a test that's reliable. It's a test that says we're not making this up. We have this history of protecting this particular right. And many courts have used it. In fact, when I read Hodes, I actually think that, to me, it reads like that's what you were doing. You were saying, well, we have this historical history of protecting personal autonomy, and you cite, all the cases are cited in the opinion, but then there's this jump to abortion, which is directly contrary to our history. And I think that's where, I struggle with the opinion. That's really that second jump. Instead of, most of the courts that I've seen that have wrestled with this issue, they just take the first jump, but you sort of the court in Hodes took a second jump. And that's
What if that
where I
second jump
struggle.
was to forced sterilization?
Well, there's a long history in our court that the government can't make you undergo a procedure.
But
And
when
there's a
our
law.
Constitution was passed, was that deeply rooted?
I think so. It's deeply rooted in our common law that a person can't be forced to undergo medical procedures that they don't want. It's a common law rule of battery. It's a battery when the government makes you, when a doctor performs an unwanted medical procedure on you. So I do think that particular right does have an historical basis.
But the
The
government,
can tell me that I have to have a more dangerous form of abortion if I would choose to do that,
Well,
because that you would take away what is at least scientifically the record before us shows is a safer form.
Justice, I would say that there are a matter of degrees, that no right is absolute. And that rights like free speech, which we hold precious, we have time, place, and manner restrictions that arguably make speech more difficult. And in this particular case, we think that when you're balancing the interests at stake, that a procedure that I know the plaintiffs take the position that a different procedure might be more dangerous, but they don't really quantify how much more dangerous. We don't really have any details. Quite frankly, it's just sort of this blanket statement. But when we're talking about protecting the value and dignity of human life, I mean,
I do have a question about that. What is the definition? Since that's kind of getting to we've spent all this time on revisiting our prior opinion, but in getting to actually what the district court decided about strict scrutiny, the identified interest here is the dignity and value. And what is the definition of dignity and value?
Well, I guess the best way to describe it, in my view, is what dignity and value we give other life. There's a Supreme Court decision. I have it in my notes, but there's the U.S. Supreme Court has said you don't get to dismember prisoners on death row. We have a state law.
But counsel, there's no evidence in this record of fetal pain. And that distinguishes all those examples that frankly distinguishes the argument that the Fifth Circuit made. There's no evidence that you put on about fetal pain. And in fact, the medical journal that you attached, as I indicated in my concurrence, that you attached to your temporary injunction arguments, indicated that fetal pain wasn't an issue until 29 weeks. And this procedure is between 14 and 20. So that's the distinguishing factor with this, right?
Respectfully, I don't agree. I don't think it is just about pain. I think it's the fact of your dismembering a human being is a horrible thing. And I think we're saying, well, you shouldn't dismember. It's a horrible thing to dismember someone on death row. It's a horrible thing to dismember a pet. Well,
But isn't there and focusing on the evidence in the record, there's evidence in the record that the moral status is unsettled about whether it's a human being, right?
I don't think it's unsettled, and right.
But would you agree that there's
state law
expert?
doesn't make it unsettled either. State law says human life begins at conception, and that's reflected in our criminal statutes and some of the other statutes, tort law, that kind of thing. So no, I don't think that is.
Would you
unsettled.
agree, though, that there's evidence in the record from an expert that says that the moral status of potential life is unsettled?
I agree that one of the plaintiff's witnesses made that statement.
Oh,
I
you don't
with
agree
that.
it's an expert witness
Well, an expert on medical care, but not
on medical
necessarily,
ethics?
but not necessarily an
it's the
expert
medical-
on the value of life. No, I don't think that person's an expert about value of life. No.
Did you challenge the expert or depose the expert?
I don't think that was done, no, Justice.
Okay, thanks. And then if the identified interest is the dignity and value of potential life, then and you're saying that it's not a legitimate interest, which the Supreme Court, the US Supreme Court has said it's a legitimate interest. You're saying it's a compelling interest. What's the difference between a legitimate interest and a compelling interest?
Well, a compelling interest is something that I think is clearly set out in the Constitution and present in our history and tradition, and one that strict scrutiny should be applied. There are, of course, lesser important interests that we may take into effect. I think of the cases, the vaccine cases that I talked about earlier. It's important, personal autonomy interests that the government shouldn't likely be forcing us to take an injection, but there may be very weighty public safety or public health reasons to require people to do that. So I think that's where, and the standard in those cases, they don't employ strict scrutiny. It's a balancing test of some kind.
So what's a legitimate interest?
Well,
I'm not really
it's something
understanding.
less than it's less than fundamental, but, you know, greater than something that's not that important. That's I'm not sure I can give you a definition.
In other words, other than your words and that you're describing today, your personal opinion about it, what evidence was before the district court to define or create the compelling interest, other than the suggestion from the state at oral argument, hey, the compelling interest is the personhood amendment? And that's kind of how that evolved, is how I read the record and what the district court did.
Yeah, we're
What
citing
evidence
to
is there?
you statutory law.
Wouldn't there be some requirement for a court who's finding a compelling interest of facts to support the creation of it?
Well,
It just seems to me this is so broad, and I don't think it really gets to the heart of this case, because that's not what you argue that the compelling interest is. You kind of jump off from that and talk about a humane way of fetal demise and that kind of stuff, and then go from there. But tell me what it takes for a district court or for us to define or state what the compelling interest is.
Well, I think here what the state's position is that preserving and protecting the dignity of unborn children and human life is a compelling interest. That seems self-evident to me. I'm
Counsel,
sorry, but I think it seems self-evident.
Piggybacking on the self-evident comment, do you know whether or not under existing federal U.S. Supreme Court precedent, the application of that prong of the strict scrutiny standard, the compelling interest prong, is that a question of law or a question of fact? Do appellate courts give deference to district courts, or do they resolve?
The question of law.
Compelling interest is a question of
Yes.
law.
I want to,
Okay.
one of the arguments in your brief made is that these procedures for fetal demise that are still legal are realistic. Seems to me that the affidavit of the testimony, the sworn testimony of Dr. Davis that was admitted into evidence and accepted by the really debunks that. But so let me give you a hypothetical. Assume you have a pregnant woman who's 15 and a half weeks in gestational age. Which of those alternatives look at to say are realistic?
I can't give you an answer to that, Justice.
I mean, I can walk through all of the evidence that the court accepted, and on each one of those doesn't work. I mean, it isn't even, you can't even argue it's realistic. A 20% failure rate, it takes 24 hours at least for the fetal demise to occur, and it may not work. And so you got to go another 24 with a second dose, and that's somehow more humane. I mean, the evidence doesn't add up to your argument. And so so what do I do with that? Seems like, I'm as stuck as you are with what happened at the district court.
I've given you my answer, Justice, and that is, I think that's why I'm pointing to other cases, because I recognize that the record is what it is. And so I'm trying to point to you some detailed evidence that was presented in other cases where judges made findings that contradict some of the evidence with regard to the workability and efficacy of some of the alternatives on D&E procedures. And so that's really the best I can offer to you.
But that doesn't even comport to due process. These guys haven't had a chance to shoot at it. I mean, it just doesn't, to say that we can bootleg evidence in from another case just doesn't seem to make
Doing the best I can,
sense.
Justice.
Let me ask you one other question. I promise I'll be done. I suspect in the next case that's up, the argument will be that the state has a compelling interest in maternal health. How does Senate Bill 95 promote maternal health,
Well,
given the evidence that's in this case?
if you're going to restrict me to the evidence that was presented in this case, it's hard for me to give you a good argument. Again, in the whole woman's health v. Paxton case, they talk about, in fact, there's studies that cited by some of Planned Parenthood's own studies that to women having abortions, it disturbs them to learn that their unborn child may be dismembered. And so there was evidence in that case that there's a component of the mother's mental health and well-being as to how an abortion is performed. So I would say that based on that information, there is an issue of the mother's health at stake in an abortion procedure such as this. But that's the best I can offer you. See that I've gone way over. So unless there are any other questions, I'll sit down. Thank you very much.
Madam Chief Justice, may it please the court, Alice Wong for Plaintiffs Appellees. 4 years ago, this court held that the Kansas Constitution guarantees every Kansan the fundamental right to personal autonomy, which includes the right to abortion because few decisions impact a person's body, health, and family more than taking on the physical risks and life-altering consequences of pregnancy and childbirth. Here, based on undisputed facts, the district court held that SB 95 violates that right because it bans the standard and most common method of abortion after 14 to 15 weeks and leaves only more complicated, less reliable, less tested, and higher risk procedures. This court should affirm the district court's rulings for 3 reasons. First, this court already concluded that SB 95 likely fails strict scrutiny because it bans the most common, safest procedure and leaves only less common and less safe alternatives. The court remanded to give the state a full opportunity to develop evidence, but the state failed to present any evidence. Second, the parties agree that SB 95 infringes the fundamental right to abortion, so it's the state's burden to overcome strict scrutiny.
Counsel, where would we be? Clear and convincing evidence demonstrated to the satisfaction of the trial court that there was fetal pain between 14 and 20 weeks, where our procedure gets used.
Your Honor, first, the state has not asserted here an interest in preventing fetal pain.
I know that, but I'm just saying, I'm trying to probe into the compelling state interest. So what would be your, if that were, something had been found by the trial court, does it change the analysis?
Your Honor, if the state asserted such an interest and put forward evidence to demonstrate that fetal pain was possible at the stages of justice, then the strict scrutiny analysis might look different. As this court emphasized in Hodes, application of strict scrutiny rests on evidence actually presented, not on hypotheticals and theories. So it's hard for me to speculate as to how it would apply to a hypothetical record that's not before this.
Justice Stiegel asked a question of counsel about whether the compelling state interest, the articulation of the compelling state interest is a legal question. And I was wondering if it isn't a mixed question of law and fact. What's your position on that?
Your Honor, I believe that there is 10th Circuit precedent holding that the compelling state interest determination law. Here it is a question of the application of the strict scrutiny facts of this case. And this court emphasized that in applying strict scrutiny has to engage in active and critical analysis of the record and make independent judicial findings, and that mere deference to the legislature's stated goal is not enough.
Well,
Just real quick, a follow-up on that same issue. If I could articulate it this way and see if you agree with me, that when it comes to determining whether a compelling interest exists or not, the process, at least as it's followed under federal precedent, is that the determination of the underlying facts are, of course, factual questions resolved by district courts using evidence. So, for example, the question of, is there fetal pain is a fact question. But then the ultimate issue of whether or not there is a compelling interest, whether or not the state possesses a compelling interest to prevent fetal pain would be a question of law. So in that sense, it's a mixed question of fact and law. Would you agree with that? Just that that's how it typically works.
Yes, Your Honor.
And then my follow-up would be, because you referenced the 10th Circuit, this is an interesting area of the law where the precedent from this case in this court's prior decision is that we're not applying federal law. We're applying state law with respect to Section 1, but we, for lack of a better word, have borrowed the strict scrutiny standard, which really hasn't been a feature of state law prior to this case. So my question is, does this court look to federal precedent on the application of strict scrutiny, or are we on our own essentially, since we're applying only state law? I guess I'm asking, from your perspective, does the state law application of strict scrutiny look identical to the federal law application of strict scrutiny?
Not necessarily, Your Honor.
And what would be the differences? And how would we know?
Well, this court refused to give the right to abortion any less protection than strict scrutiny, and it looked to the United States Supreme Court's application of strict scrutiny as a floor for applying the standard. But that doesn't mean that this court is tethered to federal law, because as this court has recognized, Section 1 provides distinct, broader protection than the 14th Amendment of the United States Constitution. However, this court has recognized in a line of cases that strict scrutiny applies whenever a law implicates a fundamental right or imposes a suspect classification. And this court has applied strict scrutiny in the past.
If we're untethered, I'm sorry.
No, just a quick follow-up. You can correct me if I'm wrong. I'm not certain about what I'm about to say, but my guess is that all those cases are our court applying federal law. I don't know at least of cases where our court has applied strict scrutiny in a purely state law question prior to this case. Are you aware of such a decision?
No, Your Honor.
And so if we're not tethered federal law, and we in Kansas regard the destruction of potential life a matter of significance or compelling interest.
A couple of points, Your Honor. First, the state has not asserted an interest in protecting potential life and concedes that that is not what SB 95 does. It has asserted an interest in promoting respect for the value and dignity of human life. And under strict scrutiny, the state must articulate a sufficiently concrete court to engage in the rest of the analysis, and it must make a factual showing that the asserted interest is the bona fide purpose for pursuing the challenged regulation.
But what does it take in your mind as we're trying to look at this to establish a compelling state interest? What does the state have to do or the government have to do? Does it take some sort of evidence, some sort of testimony, or can it be like here, it's taken from a statute that was passed more than a decade ago? How does that work?
Your Honor, it does take evidence, as this court recognized in Hodes' application of strict scrutiny, must rest on evidence and not on hypotheticals and theories. Kansas's reference to the personhood statute is not enough. As that statute expressly acknowledges, it is subject to the Kansas Constitution, and that is because this court has an independent obligation to interpret the Constitution and protect.
Well, why wouldn't the state have a compelling interest in promoting life? Does that take some sort of evidence to create or to say that's a compelling interest? I appreciate it's very broad, and that's kind of the difficulty I'm having with this, but why isn't that a compelling interest? Just promoting respect for life or something along those lines.
Your Honor, plaintiff's argument is that the state has not met its burden under strict scrutiny
Right.
of showing that interest to be compelling. That asserted interest was already before the court in Hodes, and this court declined to recognize any compelling interests at that time and remanded specifically to give the state an opportunity to present evidence, and it has not done so here.
And at this stage, it is their burden to do that.
Correct.
That gets back to the question of if it's an issue of law versus fact. Do we look any further than we do than section 1 to determine that it is a compelling interest? It uses the term life in section 1. Doesn't the term life probably include the dignity and the value of life?
Your Honor, 2 points. First, this court held, including in Hodes, that section 1 rights accrue to the individual at birth. And second, that question is not before this court because the state concedes that SB 95 does not protect potential life. It substitutes the standard and most common method of abortion with other methods for inducing fetal demise that are less safe, require additional invasive procedures, are unreliable, and are in some circumstances experimental.
Challenge is only to the method of the abortion, not fact of the abortion.
That is what SB 95 targets, Your Honor. As this court explained in Hodes, strict scrutiny places the burden of proof on the state because government infringement of a fundamental right is inherently suspect. Applying that standard, this court concluded that plaintiffs were likely to succeed on their claim that SB 95 violates section 1. It remanded, emphasizing that the trial court's resolution of the merits should rest on evidence, and the state failed to present any evidence on remand or to rebut plaintiff's evidence. It withdrew the only expert that it identified. It didn't serve any discovery requests, and it didn't depose plaintiff's witness. There are no material facts in dispute. Uncontroverted record evidence shows that D&E is the standard and most common method of abortion after approximately 14 to 15 weeks of pregnancy. There is no reasonable alternative to D&E, and inducing fetal demise prior to D&E would force patients to endure additional painful, invasive, medically unnecessary procedures that increase health risks and are experimental in some circumstances.
Counsel, I want to ask a pretty technical question about your position. Because you repeated several times that what we're here on is the state's failure to meet its burden of proof, correct?
Yes, Your Honor.
So I take from that what you're asking from this court then is not a rule of law that states there is no compelling state interest. Rather, you're asking for a ruling that the state failed to meet its burden to demonstrate a compelling state interest.
That is correct, Your Honor. I want to respond to one point by my opposing counsel. There is no evidence in the record of patient preference for inducing prior to D&E. What's also missing from the record is any evidence that alternatives to D&E promote greater respect for the value and dignity of human life. These undisputed facts are essentially the same to those before the court in Hodes when it held that SB 95 likely fails strict scrutiny. So Hodes controls the outcome here. As the district court correctly concluded, SB 95 is unconstitutional because it doesn't serve a compelling state interest. And in any event, SB 95 isn't a narrowly tailored solution. No alternative for second trimester abortions other than more complicated, less reliable, less tested, and higher risk procedures. As this court held in Hodes, banning the most common, safest procedure and leaving only less common and less safe options violates the right to abortion. Knowing that it failed to put forward anything that could justify a different outcome, the state asks this court to discard Hodes and the line of Section 1 precedent it built upon based on nothing more than legal arguments that this court already carefully considered and rejected. Stare decisis squarely bars the state's meritless request. The state hasn't shown that Hodes is clearly erroneous or undermined by changed circumstances. Hodes was
You suggest we would apply we would skip over law of the case. The basis for our staying with our previous decision.
Your Honor, I believe that law of the case doctrine and stare decisis would yield the same outcome, both bar reversal in this case.
There's no difference there, so. I would like to back up just a minute because as I recall, during the oral arguments before the district court made the observation that really nothing had changed since the decisions of what was before for her to do. And I think in the state has argued in its briefing that the difference is that had not addressed the personhood statute. In your view, does that change our approach? Does that make a difference with the application of either law of the case or stare decisis?
No, Your Honor, the personhood statute was already before the court as it was addressed in Judge Atchison's Court of Appeals concurrence. And as I discussed, the personhood statute expressly provides that it is subject to the Kansas Constitution. And the legislature can't do an end run around constitutional protections by mandating how this court construes the Constitution.
Yeah, I want to follow up on the chief's observation because I was struck by the district court judge's comments at least 3 or 4 times of what is there left for me to do? State, tell me what there's left for me to do here. And really came up with the conclusion there wasn't much other than perhaps identifying a compelling state interest, which she did she didn't really say that in the oral argument, but rendered a decision in the memorandum decision in order. But if we find the state has failed to meet its burden, what are we to do? Is that game over on this case?
Yes, Your Honor.
I'm following up on Justice Stiegel's kind of a point here. There's 2 different directions we can go. If it's the state has failed to meet its burden, is the case over?
Yes, Your Honor, this court should affirm the district court's ruling, although it can do so on alternate reasoning, and it can hold that the district court erred in finding a compelling state interest.
Quick follow-up on the personhood discussion. I appreciate your point that the statute, it seems common sense in some ways that the statute can't define which entities are or are not persons. That's your position, I take it. I mean, that's the legislature couldn't say all people are not persons, for example, because it would be subject to the Constitution.
Correct, Your Honor. My position is that the legislature can't pronounce through legislation something that is antithetical to the rights protected by the Kansas Constitution.
So what is your position about what the Kansas Constitution says about what entities are or are not persons? And earlier you made the comment that Section 1 rights are vested at birth. Is that the place at which you would argue the Kansas Constitution defines persons?
Your Honor, I don't know that this court needs to reach that question in this case. And I advocate faithful application of this court's precedent, which states that Section 1 rights attach at birth.
Would it matter if the Kansas Constitution defined an unborn child as a person? Would that matter to this case?
I believe so, Your Honor.
And so it kind of is relevant, right? Whether or not the Kansas Constitution vests personhood in an unborn child makes a difference.
Yes, Your Honor.
So I guess I'll just follow up with what would the plaintiff's position be with respect to that question?
There is nothing in the Kansas Constitution that defines person to apply to prenatal life.
Okay. But there is with respect to postnatal life would be your position.
Correct.
Okay.
If there is a different conclusion, is there any evidence before this court that the unborn child would have greater comfort under an alternative method?
No, Your Honor, the undisputed facts in the record show that there is no evidence that alternative methods of eyes are any more dignified or humane than DUI. Also, expert evidence in the record that there is no consensus that certain methods of
By humane, you are equating that with comfort to the unborn child.
Your Honor, I'm limited to the evidence that is in the record.
I guess put a different way, if any of those other alternatives are done, do we have any evidence at all as to how they would affect the child under procedures being implemented at the moment?
There is no evidence in the record of how the procedure affect the but there is evidence in the record of how those out. For instance, digoxin must be injected through a spinal needle into the abdomen or the vagina and cervix of the pregnant. Justice Biles pointed out, it must be administered at hours in advance, delaying the abortion by at least a day, and it carries risks of infection, nausea, and unplanned delivery outside of a medical setting for the pregnant person. That is what the evidence in the record shows, and there's other proposed methods. Hodes was correct as a matter of first principle. This court carefully analyzed the text, history, and structure of the Kansas Constitution. Hold that Section 1 provides judicially enforceable and incorporated a broad conception of natural rights that includes the rights to personal autonomy and bodily integrity. The court recognized that these rights belong to every Kansan, that Kansans do not relinquish them upon becoming pregnant. As few matters implicate a person's body and life more than the decision whether to continue or end a pregnancy, this court concluded that the right to abortion goes to the heart of personal autonomy. Moreover, contracting Kansas constitutional rights would inflict severe and unquantifiable harm. Without the Kansas right to abortion, there would be nothing stopping the state from conscripting Kansans into 40 weeks of forced. And in addition to the devastating health consequences, stripping away the right to abortion would propel women backwards and exclude them from the promises of
Apologies for mispronouncing your. Five minutes.
Very much. I don't think I'll need all that time unless you have more questions for me. We've been here.
Well, I have
Long
a
time.
quick follow-up.
Okay.
And I just want to
Very
give
good.
you the same opportunity to ask answer the same question I asked your opposing counsel, which is, from the state's point of view, would it matter if the Kansas Constitution defined an unborn child as a person?
Matter.
Yeah, would it matter to this case if the Kansas Constitution assigned the legal status of personhood to an unborn child?
I think it would affect the result of what Hodes court decided. I don't think it would affect our position. That is essentially our position.
Okay,
is
well, so
that-
that's my follow-up question. Did you make that argument? Did you argue that the Kansas Constitution confers the legal status of personhood on an unborn child? Was that argument made in this case?
I don't recall us making that argument.
Yeah, I don't think it was made. I mean, I think the argument was made about the statute.
I think our view is that the legislature, and we agree that personhood begins at conception. But it's not in the Constitution. We haven't made that argument.
So that might be an argument or an open question that might matter, but we can't reach it in this case. Is that correct?
Correct.
Okay.
let me just make a couple of brief points and then I'll try to answer your any questions that you may have. First, with regard to the interest in fetal life, Roe said that the state has a valid interest in fetal life. And given Dobbs, it seems to me
In
that
the third trimester.
right, post viability.
And that's
third
not an
trimester.
issue in this case. So,
Right, right.
Okay, so
But our view is that we have an interest in pre-viability life as well. And I think that, Dobbs in its discussion about abortion and why abortion has been illegal through most of our history until Roe, talked about the common law authorities talking about the moral wrong of abortion. And
how is that implicated? That was the point that I picked up from opposing counsel. With SB 95, we are only talking about the method of fetal demise, whether there's a realistic alternative to the one that's been outlawed. So I don't see that the interest in potential life, I understand the phrase dignity. I understand that part of it, but just the notion of life doesn't enter into this, does it?
Not totally. No.
How at all?
The
How at all? Because we're only talking about how we go about fetal demise.
Fair enough. Fair enough. It's really a corollary of that. We have an interest in fetal life, but it really is about the value and dignity of human life. And that is what we're really getting at, I think, in the dismemberment case is the assault on human dignity with dismembering a live unborn child. That's, I think, the essence of the interest that we're talking
As
about.
opposed to amniotic poisoning of an unborn child over a 24 or 48-hour period, right?
Well, that's your characterization of it, Justice. I don't
I'm
agree
just
with
going
that.
from the evidence in the record. And the evidence of the record is that it takes 24 hours for one of these procedures. And then the other one, it's transecting the umbilical cord. You want to tell me that's not
Again,
terrible?
I'm at a disadvantage because of the record in this case, but I will say again that in Whole Woman's Health, they had a different description of what fetal demise through drug like digoxin has on it. And the record in that case says that can be done more than once without, it's not torturing the child, that it's actually a more humane
we're going to hear
method. So,
cases all week, and I can't wait tomorrow for the appellate defenders to come up and tell us that we ought to look at evidence that was presented in some other criminal case. And so my position would be when the prosecutor gets up, am I supposed to tell them the Solicitor General just gave up the argument that we shouldn't look at all this, that the evidence that was introduced in a whole bunch of other cases?
fair enough, Justice. The way to solve that, I guess, is give us a remand and we'll put on more evidence and maybe that can solve all those problems.
Maybe you
but-
can figure out a way to make 60-1507 apply to your case.
Okay,
But
very good.
let me ask you, can
But-
the state compel a pregnant woman to give birth?
Can the state compel a pregnant woman to give birth? Well, a woman gives birth, that happens without the woman doing anything. It will happen. So
Against her will. Let's just add that, against her. Can they compel a woman to give birth against her will?
question, I would say I don't think the law, Kansas would ever pass such a law, but it happens automatically without a decision. I mean, the
But hasn't it
decision
done it?
when
I
a
guess
woman
my
gets
point is,
pregnant.
hasn't it done it in this case? Because you can't articulate for me in my hypothetical how there's a realistic alternative to the outlawed procedure. And it seems to me if the state legalizes something that doesn't work or works with horrible consequences, it's really trying to just simply have a pregnant woman be compelled or to give birth against her will.
Okay.
And it's that, and can the government do that?
Well, because if it means saving a life, I think I suppose you could do that, but you're talking a hypothetical that I don't see the realistic application of
The
that.
realistic application are the facts in this case. You take away the alternatives that are legal, you make illegal the safest medically acknowledged procedure, that only leaves one outcome, right?
Justice Biles, again, I'm just gonna, you want me to admit something that I think there's evidence to say otherwise. I appreciate the fact that the record in this case has got me boxed in, but I'm not gonna stand at this podium and agree with that statement. I'm sorry, Justice, I'm just not gonna do that. But I think you've made your point with me, and you're the one that's gonna obviously decide this case and not me. The other point that I wanted to make, and it was about the point that Justice Rosen made kind of right out of the chute about stare decisis. I think it's an important point because I think of the line, it's one of my favorite movies, a musical, 1776, and Benjamin Franklin makes the point that treason is a charge that's invented by the winners as an excuse to hang the losers. And I sort of feel like stare decisis is like that. The winners like stare decisis because they want to keep the rule that they support in place without revisiting the merits. And there's obviously some good practical reason for doing it. But in a case like this, when we're dealing with abortion and a controversial constitutional right, it seems to me that those doctrines have to give way to making the right decision. If you look at it hypothetically and say, if the court in Hodes made a mistake, you don't want that important constitutional rule to be left unchanged and allow doctrines such as law of the case or stare decisis to stand in your way. You're going to want to reach the merits of the case. And so that's really my final point. If there are no more questions, we just ask that this court reconsider Hodes and reverse the decision in Hodes, and based on that decision, reverse the district court and uphold the dismemberment statute. Thank you for your time today.
And thank you to both counsel for your arguments this morning. The court will take this appeal under advisement.